For the record, this matter is before the court at the request of the Attorney Time Coordinator Stephanie LaPrade to address school district for the minor child. This hearing is being conducted via Zoom. Present is the plaintiff, Father Michael DeGroot. Also present is Attorney Lisa Gazzari, representing the defendant mother, Sarah Hisenkamp, and Ms. Hisenkamp is present, as well as Ms. LaPrade from the court. Good morning, everyone.
Good morning, Your Honor.
Morning.
Mr. DeGroot, can you hear the court?
Yeah, I can hear you.
Okay, just want to make sure everyone's on board here. We got the parties have control from Ms. LaPrade this morning. Mr. Perez, right to court find recommendation that the minor child Jackson shall continue to attend Jackson County Public Schools. Parenting time shall be as follows. Shall have the second, third, and fourth weekend of every month. Fridays at 6 p.m. until Sunday at 6 p.m. Both parties shall have 2 non-consecutive weeks during summer for vacation with 30 days notice to the other parent. And the parties shall follow the Monroe County Friendly Court holiday schedule unless they agree otherwise. That's the recommendation this morning. Mr. DeGroot, do you understand the recommendation?
I do.
Do you have any objection to the court adopting this recommendation?
No.
Right, Ms. Gazzari, is your client agreeable or opposed to this recommendation?
My client is agreeable to the recommendation, Your Honor.
Wonderful. So Jackson will be starting kindergarten in the fall, correct?
Correct.
Correct.
So, and he's currently attending school in the Jackson area.
That's correct.
So this order, he would attend kindergarten in the Jackson Public Schools, correct?
That's correct, Your Honor.
Right. Wonderful. Thank you. Mr. DeGroot, can you state your name and current address for the record, please?
Michael DeGroot.
Mr. DeGroot, do you believe this recommendation is in the best interest of your son at this point in time in his life?
At this time, it's the best we can get, yes.
Okay, that's what we'll focus on right now. Things can change in the future. We need to focus on what's best for him right now. Do you have any questions for the court?
Not at this time.
Right. Ms. Gazzari, do you have any questions, first of all, for Mr. DeGroot?
No, the only thing I will just add is as what was contained in the brief that was filed, Ms. Hisenkamp is going to apply for school of choice for Northwest Early Elementary in Jackson, Michigan. I believe that is a Jackson County public school. When I look up online, it says it's a Northwest Community School, which is also a public school within Jackson. So I just want to make sure that that's clarified. The school that she is applying to is a public school within Jackson County, and it's about a mile from his current preschool.
And the court would request Ms. Hisenkamp provide that information to Mr. DeGroot in terms of the name, the location, address of that prospective school, so that he can have a chance to research that school as well. But obviously, if it's within the Jackson County School District, then that's satisfactory. Do you have any questions for Ms. Hisenkamp? Do you have any more questions, Ms. Gazzari?
Your Honor, I would just, the question that I have for Ms. Hisenkamp is, do you agree with the recommendation that was made, and are you willing to accept it for your son?
Yes. Yep.
And do you believe it's in the best interest of Jackson?
I do.
Thank you, Your Honor. I don't have anything further. Very well. The court would like to thank and acknowledge Mr. Pratt for fine assistance this morning in this matter. The court applaud you, Mr. Good, Ms. Hisenkamp, for reaching your own game as parents. The two of you know what's best for Jackson better than anyone in this world. So continue to communicate for his best interests. But the court finds this agreement to be investors for kind of the minor child Jackson probably adopt agreement. Right, that will conclude this hearing. You can all zoom out and have the rest of the day. And for the record, this matter is before the court for the purpose of reviewing father's parenting time, in addition to address the plaintiff's objection to a child support recommendation. This hearing is being conducted via Zoom. The president is Attorney Christine Hills, representing the plaintiff father Robert Moss. Mr. Moss is present. In addition, defendant mother Tiffany Budell is also present. Good morning, everyone.
Morning, Your Honor.
Parties have conferred this morning with Mr. Walker from the front of the court.
Yes, Your Honor, I'm in the process of trying to get that recommendation to you right now.
Court would also note for the record that the last time the parties were before the court, February 13th, the court did refer the issue of custody parenting time to the front of the court for formal investigation recommendation. The front of the court, Catherine Scott, has recommended that the parties continue joint legal physical to defend mother. Court has now received the recommendation of Mr. Walker this morning, which is as follows. Parenting time shall continue as briefs ordered by this court. Father's parenting time shall be supervised by family counseling shelter services. Each party shall pay for their own intake. Mother shall pay for all sessions. The defendant's objection to the child support recommendation scheduled with referee McKeon for April 16th, 2024 at 9 a.m. be vacated. Further, with respect to child support, Ms. Walker is recommending that commencing January 1st, 2024, that the plaintiff father pay child support in the amount of $1,452 per month.
Your Honor, there's I'm sorry, Your Honor, there's a section that I forgot to put in. I apologize. There's a section that I forgot to put into my recommendation. Mr. Moss is stating that he may have given direct payments to the other party for child support. And I was going to add in there that if he can provide proof that there were payments directly paid to her for January, February, and March, that the friend of the court would give credit for that. So I need to add that to my recommendation. I apologize for that, Your Honor.
Okay, thank you, Mr. Walker. It's further recommended uninsured medical expenses be shared as follows. Plaintiff father paying 65%, mother paying 35%. That is the recommendation. Of course, where we have a 18-month-old minor child here. Ms. Sills, with the addition of the language suggested by Mr. Walker, that Mr. Walsh received credit for any direct payments made to Ms. Budell upon providing proof. Your client agree with this recommendation?
Yes, Your Honor. It's my understanding with respect to the parenting time recommendation that the current order regarding parenting time would continue only until the family counseling and shelter services is able to accommodate a visit. I know that they have a wait list of several weeks at least at the moment. So I'm not sure if Mr. Walker's intent was that the supervised visits with mother continue once family counseling is involved, or that those stop once family counseling is involved.
The intent was that once family counseling and shelter services begin supervised visitation, mother would no longer have to supervise.
Okay, thank you. And I may have just misheard the reading of the recommendation. So thank you for that clarification. With that, Judge, we are not objecting to Mr. Walker's recommendation today.
Okay, so if the court understands it correctly, Ms. Sills, that the current parenting time for dad, which is supervised by mother at Chuck E. Cheese's on Sundays, noon to 4, Wednesdays 5 to 7, Fridays 4 to 6. That would continue until such time as the supervised parenting time would commence at family counseling and shelter services, and at which point in time all supervised parenting time would be at that agency.
Yes, and I would suggest and hope that the parties contact the agency as soon as possible to get on the wait list so that there's not any delay.
Yes. Can you provide the parties with the phone number?
I will.
Okay, so Ms. Budell, you need to contact the agency as soon as possible to schedule your intakes. And that's the first step to getting on this wait list. All right, so thank you, Ms. Sills. And Ms. Budell, do you understand the recommendation this morning?
Yes, I understand.
Okay, do you have any objection to court adopting this recommendation?
Yes, I do.
Okay, what's your objection?
My objection is I don't want it if I have to pay for it. I'd rather supervise the visits myself, even though it's I don't want to take the money away from my other 5 children. Like, I have 5 children. He has just Shiloh. Like, I don't want to pay for his supervised visits because he's lying. You know what I mean? I don't want to.
No, what do you mean he's lying? What does that do with parenting time?
Because that's what happened, Your Honor. We both filled out the investigation and all of. Well, he didn't even fill out.
Why don't you sit down, please? You're walking around the room with
when I
the
get
phone in front of
nervous.
you.
I'm sorry.
Can you sit down, please?
Yes. So we both filled out the paperwork, and then we got the order for child support, and I objected to it because it wasn't accurate. I make $5,000 and it said he makes $6,000 a month. Well, that's not accurate at all. So I objected to it. Then 2 days later, they object to it, saying that he makes even less than that. And I'm just like, I don't feel like it's right that I have to keep being so nice and supervising the visits and, you know, all this stuff. And he's just going to keep lying and trying to cheat Shiloh. So that's what I said. I said,
testimony from Mr. Moss this morning. So what is he lying about? His income?
Yes, Your Honor. If they're saying I make $5,000 a month, how does he make $6,000 a month if he has all these houses and all these bills? And we have to use our common sense, not just the little bit that he provides of information he provides. So I objected to that. So when I objected, then they turned around and objected, which didn't even make sense because, you know what I mean? If you look at his assets, I turned in some of them as proof to friend of the court. I turned in a lot of evidence, I feel like. And then he objected to it, but I'm already coming out of money doing all these supervised visits for him, and he's going to still try to cheat Shiloh. So that's why I said, I don't want to keep supervising the visits if he's going to keep trying to cheat my daughter. And then he said he don't want to pay for daycare so that I can work. He wants to be the babysitter. Well, I can't depend on him because he's evicted me and my kids before. So clearly he don't care if we have a roof over our head. So me and my kids can't depend on someone like that to provide childcare for the family. This just didn't go good today at all, Your Honor, at all.
Well, we actually have a lot of anger inside you, Ms. Bedell, and I understand this frustration. But again,
yeah, you're
we've got
supposed to be
issues. Hold on. One is parenting time, one is child support. You object to everything, correct?
The initial friend of the court recommendation that I saw, I didn't object to that. But then when Mr. Walker said that if I want supervised visits through the court, I would have to pay for it. Well, now I'm taking money away from the other 5 kids. I can't do that. So I'll just continue to be humiliated and supervise the visits if we could do that. But I wanted his income looked into because that's not accurate, Your Honor. And I'm not coming to this court lying about anything.
Let's deal with one issue at a time, man. There are 2 different issues. Ms. Sills, if she doesn't want to pay for the visit, I don't know. First of all, what are the costs for the visits? Is it $30 a session?
$25 or $30 a session, I believe.
Okay. And if she doesn't want to pay that, what about continuing if mom wants to take time and supervise 3 days a week? Does your client oppose to that?
Mr. Moss, in light of what we spoke about with regard to family counseling and shelter services, are you willing to either continue with Ms. Bedell supervising your visits long-term, or at least as long-term until the court orders at some point that your visitation should be unsupervised? Or are you willing to take on some responsibility for the payment at family counseling and shelter services of the $25 to $30 a session?
I definitely don't have no extra money at this time. So I guess we'll just have to do what we have to do.
In terms of having her continue to supervise visits?
Yeah.
And you've indicated that there's not this sort of vitriol during the visits as in regard to you, that your daughter is insulated from this back and forth between the 2 of you that we've seen today?
So far, but after today, just like she said, she's being humiliated. And then all I see is this is about money. All this is about money.
Mm-hmm.
Yeah,
Okay.
Ms. Hills, in further consideration, there is some value to dad having time with the minor child without mom being present, a third party.
I agree.
So what the court's inclined to do is each party shall pay for their own intake, and they should contact the agency as soon as possible, and the party shall share equally the cost of the sessions. We're going to review this in perhaps 6 weeks. And at some point in time, hopefully we'll get positive reports from an independent third party. Maybe we don't need the supervised parenting time. That's the hope of the direction we need to move in, is to limit the supervised parenting time. And I think it's appropriate to observe the relationship between dad and minor child without mom being present, so that we can make a determination whether or not dad is capable of providing caring for this child without mom or some other supervisor being present. And establish a relationship between dad and the child, so the court believes that would benefit the minor child. we're going to continue the supervised parenting time with mom supervising on Sundays, Wednesdays, and Fridays as brief order until such time as family counseling child services is available. I'm going to schedule supervised parenting time sessions, at which time hopefully be every week, whatever that age you can accommodate, and that'll be just dad and the minor child Shiloh. And the party shall share equally shall share the cost of those sessions. So the court's going to modify the recommendation in that regard with respect to child support. Mr. Walker, can this be referred for formal investigation recommendation? Child support, so the parties are required to submit financial documentation to verify income. Ms. Vidal is disputing the reported income of Mr. Moss. Now,
We
I
can
don't have
do
the
that.
benefit of a recommendation, and I know it's object to recommendation. It's not in the court file. I have no idea who did the recommendation, what kind of information they used.
Your Honor, there was a formal recommendation done. My client provided a tremendous amount of income information. And I'm looking to see who did the recommendation.
Stephanie LaPrade did the recommendation.
I did the recommendation, Your Honor.
Okay, so there's been signed statements signed by the parties in terms of verifying their income, correct?
Correct.
Right. So Ms. Vidal, you can go to the front of the court and get a copy of the information that Mr. Moss signed, and if you find that he is misleading the front of the court, that's basically come back and address this thing further. But at this point,
100%. Oh, I'm sorry. I thought you asked me a question.
But at this point in time, the court's declined to adopt the recommendation. And until you can provide other allegations that his income is not accurate, he's provided written documentation in the front of the court. And that's the front of the court has adopted, has made this recommendation based upon the review of the written information provided. Presumably did that include the last year's tax returns, Ms. Ills?
That is my understanding, yes.
Okay.
Your Honor, the last 3 tax returns were included in the packet that was turned in.
All right, thank you. So the front court has all the financial information necessary to make this recommendation, Ms. Vidal.
So he lied to the IRS and now we have to just accept that? Is that what we're saying? Is that what's going on? Because ask Mr. Moss how much he paid the mortgage payment a month.
If you believe he's committing fraud, you can contact those agencies and allege that.
I just want Shiloh to be properly provided for. If he's paying $10,000 in mortgage payments right now and he used to pay $20,000, he can't only make $6,000 a month if just his mortgages cost $10,000.
Okay,
That's where my anger and frustration is coming from.
In front of me, Ms. Vidal, the court suggests is contact legal services attorney and make a petition to court and show that Mr. Moss is understating his income and his ability to pay.
Why do I have to have an attorney to do that?
Tax returns.
That's what I want to do, Your Honor.
Okay, all right. You have the right to do that. You can still petition the court to challenge us, but you need to have some proof that there's been fraud on the part of Mr. Moss in terms of his financial situation.
I guess I'm not understanding what I'm doing wrong then.
Provide documentation that he's committing fraud. It's a proof rather than just allegations.
Where's his? Like just Big Emmett, he sold for $420,000 and he owned it outright. So I'm not he's getting ready to sell Breast Road. He's going to clear $300,000 on it. I mean, I'm not understanding. He sold West Road, made 100 something on that last year too. Like it's big money. So I'm not understanding how he only makes $1,000 more a month than I do. I'm not understanding. You see,
Presumably that's all been disclosed in his tax returns. He could have had significant debt on those properties too. I don't know if
but that wouldn't be, but that's not
$100,000.
That's not accurate.
Okay. Well, you can conduct discovery, Ms. Vidal. You can submit interrogatories, request for production of documents to Mr. Moss, and you can get a copy of those things.
Yeah, Your Honor, I'm sorry, I'm not familiar with what I want to bring in my evidence and I want to present my evidence. I don't understand like this remote stuff. I want to dress up and come to court and present my case.
You present that to the front of the court. I mean, the front of the court is also has already conducted the investigation. That's when you should have provided all that information.
So that's what I did, and then I objected to that when they did the discovery because it wasn't accurate. So sorry, I'm starting to pace. Let me sit down. So I objected to that, and then I want to come into court and present my evidence.
Okay, well, we'll leave on the hearing then. You can appear for referee McKee on April 16th at 9 a.m. We'll keep that on. You can come in, Mr.
Yes.
McKee, with all your documentation. So, Mr.
Yes.
Walker, we'll leave that hearing on for Mr. McKee. The court's inclined to adopt the recommendation this morning. If Mr. McKee, you can address it further on April 16th at 9 a.m. So we'll leave that date on, Mr. Vidal. You can come in person, talk to Mr. McKee, and provide him the documentation and show him proof that Mr. Moss is submitting fraudulent tax returns, and they make a complaint with the IRS.
Your Honor, I am not available on the 16th. That's a travel day for me, so I can't even promise I could stop somewhere and join in a hearing.
Okay.
So I'm wondering if we could get a new date before Mr. McKee from front of the court. I'm certain my client is going to wish me to be there.
Okay. Mr. Walker, do you have access to Mr. McKee's schedule? Can we take a break? You can call him and we can change it from April 16th to a different date.
Your Honor, we can put that on April 30th at 1 p.m.
We'd be available then, Ms. Hills?
I can make that, Judge, I've got a 1:30 with you that day. So as long as you're okay with that, I'm okay with that.
Absolutely.
Okay.
Okay. So,
Your Honor, I can add that to my recommendation. Stephanie, can you give me the date one more time?
April 30th, 1 p.m. with referee McKee.
thank you, Mr. Pratt.
Your Honor, the only other thing is, because they're both self-employed, Mr. Moss provided the last 3 years, Ms. Budell did not. So we would also need the 3 years for her as well, if we're going to be making accurate recommendations to the court.
You understand,
I
Ms.
don't have
Budell?
21s. I don't have 21s. I gave everything. I didn't file in 21.
I'm
I
saying
gave
you did not
everything.
file in 2021?
No,
Like, you had no income?
no, because I didn't realize until I just had to submit my paperwork, but it's probably because my company changed names mid-year. So I probably missed it because I probably got one from Landmark Realty and then one from Compass Realty and just, I don't know, maybe I got confused or something. But I just realized that when I had to I don't turn in my income for anything else, so I didn't realize it.
There should be a social security statement available. She should be able to set up an account online, which will give a history if there was withholding done, which will give a history of the.
I'm self-employed, so it doesn't, but I just have to find my 1099 from Landmark and then my 1099 from Compass because my brokerage changed names halfway through the year in 2021. So I'm guessing that's what happened.
Well, each of those brokers should be able to provide you with the documentation of your income while they were your broker. So reach out to those brokers and try to secure that information, Ms. Vidal, for this hearing on April 30th at 1:30 p.m. You can 1 p.m. April 30th, 1 p.m. We'll put this in this order this morning that your objection to the child support recommendation can be heard by referee McKee, not on the 16th, but rather the April 30th at 1 p.m.
Okay.
And you need to get that documentation together. Ms. Hill suggested go online with Social Security. They can have that information. Obviously, if you had taxes, I don't know if you're a broker, if you're self-employed, they would not have withheld any tax, but you had an obligation to still pay tax on their income.
Your Honor,
Secure that documentation.
once
At
you
this
file
point in time, the court's going to order that commencing as of January 1st, 2024. And Mr. Moss paid child support $1,452 per month. Parenting time will continue as previously ordered, namely, mom will supervise for 3 days a week at Chuck E. Cheese's until such time as there's an opportunity to have supervised parenting time between dad and the minor child shallow with family counseling child services. Both each pay your own intake fee, and then the parties should share equally these fees for the sessions. And the 5% is for review in about 6 weeks. Hopefully, we've got some reports from that agency, Ms. Hills.
Your Honor, Mr. Walker's indicated that the wait list is currently about 6 to 8 weeks.
Okay, so maybe 8 weeks then.
June 4th, Tuesday, June 4th at 2 o'clock.
I have a trial that day with Judge Arnold, Your Honor.
Wednesday, June 5th at 8:30.
I can do that.
So please contact Angie today. Get on the sooner both of you need to contact them today and make that appointment for the intake to move this matter forward. All right, anything further this morning, Ms. Hills?
No, Your Honor.
Ms. Budell, anything further?
No, Your Honor.
Okay, so the All right, the court will adopt the recommendation as revised to be mailed a copy. We'll see you back in June then.
Thank you. April?
Right. Well, yeah, well, that's before referee McKee. You're not gonna be before this court. You can be before this court for review in June, review the parenting time.
Okay, Your Honor.
The objection to the child recommendation will be heard by referee McKee in person on April 30th at 1 p.m. rather than the 16th.
Okay.
Okay.
Court is now in session. Top of page 1, Robert Moss versus Tiffany Bedell.
For the record, this matter is before the court this morning for the purpose of reviewing parenting time. This hearing is being conducted via Zoom. Appears that the plaintiff, Robert Moss, is present. Mr. Moss, are you still being represented by Ms. Hills?
No, sir.
All right.
She is no longer.
Okay, your response was unclear. The answer is no. Is
Oh,
that
okay.
correct?
Can you hear me now?
Yourself? Yes, much better.
Yes, that's correct.
Okay.
Yep, that's correct, sir.
All right, is Tiffany Bedell present on audio?
Yes, Your Honor.
All right, good morning, Ms. Bedell. The two of you have conferred with Ms. Brower this morning. Good morning, Ms. Brower.
Good morning, Your Honor.
Ms. Brower has provided the court with the following recommendation. And now, is Shiloh, she's still 1 or she 2? Close to
The
being
1.5,
2,
she's 20 months, Your Honor.
okay, all right. The recommendation of Ms. Brower for the front of the court this morning is that father's parenting time supervised by Tiffany be terminated, and that father shall have supervised parenting time at family counseling shelter services when it's available. As previously ordered, each party should pay for their own intakes. The parties will share equally the cost for each session. Ms. Brower has provided in the recommendation the phone number for that agency. The parties will report back before this court to review parenting time on August 21st, 2024 at 2 p.m., which is a Wednesday. Mr. Moss, do you understand the recommendation?
Yes, sir.
Do you have any objection to the court adopting the recommendation?
No, but I'd like to bring to the court's attention that the parenting time that I had was basically not ever done because of, I guess, these court hearings are streamed through YouTube, and I guess they put our pictures on YouTube and said something about crazy baby mama or something. And she like blew her lid when we was at lunch, and she basically told me she ain't let me see my kid. She ain't going to court, and basically she's going to move out of state. And that's what I was taking. I was like, it was kind of disturbing, to be honest with you.
Okay, and I don't know what you're talking about. There was a court order that you have supervised printing time on Sundays, Wednesdays, and Fridays. And
that's correct, and I have none of those.
Okay. Well, it's unfortunate. Obviously, there's conflict, and that's why this recommendation is that you go to this agency. Unfortunately, there's a waiting list for that agency, so you should call them today. Did you write down the phone number? Don't wait for.
Yeah, I already got all the information. I will.
Sorry?
I will.
Do you have their phone number?
Yes, sir.
Okay, 241-0180. And Ms. Bedell, you should also call them today. You both need to move on this to get on that waiting list.
Oh, I've already got on the waiting list, Your Honor.
We'll call back just to make sure you're on the waiting list.
Oh, they already contacted me. I just needed to get the court order, and I couldn't find it. I was going to send it to me, so I got it all updated. Now I'm getting to it today.
Okay, well, you'll get another updated order. Ms. Bedell, do you understand the recommendation today?
Yes, Your Honor.
Do you have any objection to the court adopting the recommendation as an order?
Not at this time, Your Honor.
Okay. This YouTube, because of the fact that our proceedings are being conducted via Zoom, we have to stream it to YouTube because it's an open courtroom. But we erase it at the end of the day. So I don't know who's picking it up. But anyway,
yeah, and Mr. Moss is not being.
Put aside that. You know, I don't pay attention to social media. Is it true that you denied Mr. Moss the parenting time he was previously granted?
Yes, Your Honor. While we were at dinner,
and hold on, stop right there, Ms. Bedell. Why?
Video.
This is a court order.
Yes, because he acted aggressive during the visit while all my children were present, and Buffalo Wild Wings does have video recording in the restaurant that we were in. So after that time, when I brought it to his attention about the YouTube videos, I was quiet about it. He got up in the restaurant, got up, grabbed my baby, Shiloh, and walked over to a completely other table. All my children are present there. And he starts yelling at me about he doesn't use Facebook. And I said, yes, you do. You can see where you're on there talking to transvestites, telling them that they look good. You can see that he comments on their posts. You can see that. So that's when.
That has nothing to do with all this. All right, hold on, Ms. Bedell, right there. We're not going to waste a lot of the court's time. The two of you are acting like children. First of all, Mr. Moss, that's totally inappropriate. If you did that, totally inappropriate. Why in God's earth do you do that to create issues is beyond the court. So the court's going to adopt this recommendation. Rather than mom supervising, it's to be supervised by a third party.
Correct.
So, Your Honor, can I speak?
No, the court doesn't want to hear anymore. The two of you are being silly, and come on, your parents.
Yeah, but Your Honor, I did not do that, Your Honor.
This is a 2-year-old child. Court will adopt the recommendation.
I didn't do that, Your Honor.
You both be mailed a copy. We'll see you back here then on August 21st at 2 p.m.
Your Honor, can I just have it on record that was not true? That did not happen. She's the one who got upset, and I had the baby in my arms. I was already holding her, and I had to get the bill.
It's noted for the record, Mr. Moss, your denial that it took place, but in any event, from now on, parenting time will be supervised by the third-party agency. So both of you contact agency today, make sure you're on that waiting list.
Yes, sir.
So we can move forward on this. So your dad needs to establish a relationship with his child. All right, that will conclude this hearing.
Thank you, Your Honor.
Both zoom out. Thank you, Ms. Bauer.
You're welcome, Your Honor.
Thank you, Your Honor.
Good morning, Ms. Hicks.
Good morning, Your Honor.
Court is now in session. Melissa Griffin versus Jesse Griffin.
Are you Jesse Griffin?
I am, Your Honor.
All right, good morning. For the record, Mr. Jesse Griffin is appearing this morning via Zoom from the Monroe County Jail. Also present is Monroe County Front of the Court Attorney Rebecca Hicks. Mr. Griffin, can you please state your name and your current address for the record?
My name is Jesse Lee Griffin. I live on 10.
Okay, is your post office box of 35?
Yes, it is, Your Honor.
Okay, we have your current address. Ms. Hicks, can you provide the court some information regarding Mr. Griffin and this particular file?
Certainly, Your Honor. In this matter, it is an arrears only case. However, he does have a felony non-support conviction where his probationary term is that he must pay his arrears off at the rate of $500 per month. He does have a previous finding of contempt with a friend of the court. It is from August 28th of 2017. It is a first finding and there is a 35-day balance. The current bench warrant that he has resulted from his failure to appear at a referee hearing on February 14th, where a bench warrant was recommended. The objection period for that expired on March 8th. A bench warrant was issued on March 15th, and it appears that Mr. Griffin filed an objection to that bench warrant also on March 15th. But at that time, the 21-day objection period had already passed and the bench warrant had already issued.
Mr. Griffin, is your probation being violated?
I've talked with my probation officer. He hasn't. I haven't been violated yet. I'm not 100% sure exactly how that works.
Ms. Hicks, when was the last payment made by Mr. Griffin?
He actually made a payment yesterday, Your Honor, of $500.
Okay, but did he miss a number of months?
He did, Your Honor. So the hearing on February 14th was adjourned. They were before referee McKee on December 13th. At that time, the recommendation was to adjourn it to February 14th and for Mr. Griffin to pay $900 that was still owed from August, September, and October, as well as his obvious $500 per month current support payment going forward. And when they came back on February 14th, the referee's findings were that he failed to appear and he had not made sufficient payment towards that amount. So he recommended a bench warrant.
All right, thank you. And as far as you know, the probation is not being violated. Is that correct, Ms. Hicks?
That's correct, Your Honor. And I would guess that they don't intend to, based on the fact that he did pay $500 this month, and it does appear that he paid $500 in March as well. But he wasn't in compliance with some months worth, nor the court order following his December 13th show cause hearing.
Right. Thank you. Mr.
Your
Griffin, are
Honor.
you currently employed?
No, Your Honor, I'm medically retired through the military.
Did you collect Social Security?
Your Honor, he
No, I do
receives
not.
VA benefits, which the friend of the court cannot get through income withholding. So he must make the payments directly himself.
All right. So, Ms. Griffin, you need to pay those payments directly yourself. How much do you receive per month?
How much say again, Your Honor?
How much do you receive every month from the VA?
About a little over $3,000. Matter of fact, I just had 2 of my kids fall off my VA benefits, so I actually get less than that now.
How much do you receive per month from VA?
A little less, or a little over $3,000.
Okay. All right, Ms. Hicks, it appears appropriate to impose some jail sentence and require that Mr. Griffin post perhaps a $400 cash bond to make up for ways fair make the one payment. What's your recommendation?
I'll see here.
Yes, Your Honor, the friend of the court would request that he be sentenced to 7 days immediate jail. I do believe he would be entitled to 1 day credit for today, or that he pay $500.
Do you understand the recommendation, Mr. Griffin?
Say again, Your Honor?
Do you understand the recommendation? 7 days in jail, but he can be released today upon posting a $500 cash bond.
I understand
your benefits.
I paid on the first when I got my benefits.
Okay, so that was just yesterday. You received $3,000 yesterday, correct?
Yes.
Okay, so when you have someone reach out and post a bond on your behalf, and you can be home for dinner tonight, and you can pay them back.
I could have somebody post the $500. They just took all my federal and state income tax. So the $500, I understand. I can pay $500, but she just got well over $6 grand from me for the state, or for February, and then March she'll get my state income tax returned. I understand that I missed some payments. That was due to the fact that they stopped my pay because they did not drop my kids from my, once they turned 18, they didn't drop off. So I'm actually paying in the rearages to them as well.
Why did you appear on February 14th?
I wasn't aware of the date.
Mr. Griffin, you were mailed a notice and you appeared in December. The matter was adjourned for December to February 14th. So you were aware of the date?
Your Honor, we go almost every month. So every other month, I lost track. Yeah, it was Valentine's Day. I didn't. It's a weird one. I don't know, Your Honor. I'm sorry.
Is there anything you want to say before the court imposes a sentence?
Your Honor, I try to pay my child support as I can. I mean, I got house payments, and I do take care of my kids.
To pay $500 per month, you can't miss payments, Mr. Griffin. It's very simple. So it's order of this court that you order to serve.
When they don't pay me, Your Honor, I can't pay payments if I'm not getting paid.
And you're not getting paid. Here's what you do: you come in and talk with the front of the court. You come in and talk with Ms. Hicks.
I did, Your Honor. I did. The referee, Mr. McPete, he was aware of my situation.
That was in December. You were ordered to appear back in February to update the front of the court, and you did not appear. So the sentence of this court, you're ordered to serve 35 days in Monroe County Jail as follows: 7 days immediate. You're given credit for the 1 day you have served. So that means a balance of 6 days, but you can be released immediately upon posting a $500 cash bond. So reach out,
Yeah.
make a phone call, get $500. You can be home, post that, been cash afternoon, you can be home for dinner tonight. We're gonna give you a date to appear before, for another review. And you need to appear that date, and the copies we mail to you, and copy will also be emailed over to the jail. Ms. Six, what do you suggest for a review date?
June 4th at 1 p.m., Your Honor.
And so what day?
June 4th?
1 p.m.?
Yes, 1 p.m.
Thank you. Right, Mr. Griffin, you're ordered to appear before the front of the court, before Ms. Six for review on June 4th, 2024 at 1 p.m. June 4th, you'll be mailed a notice.
Your Honor, so do I still have the court appearance on the, I want to say it was like the 22nd? I thought I was supposed to appear in front of you because I did file the paperwork regardless if I did it in time or not. But I did fill out the paperwork and they did say I had a court date with you. Is that true? Because I have some other information, I got receipts, because I'm paying
Yes,
on
Mr.
rear
Griffin.
right now.
Mr. Griffin, in answer to your question, you filed a objection to a referee recommended order during April 24th at 10:30. I'm not sure what the recommended order was, but from the review of the court file, it does appear that you have a hearing before this court April 24th at 10:30.
Yes, Your
2
Honor.
weeks from tomorrow.
Your Honor, that was his objection to the recommendation for a bench warrant. It was not timely filed, but
Okay.
it still managed to get scheduled.
So, Mr. Griffin, I answer your question. It is scheduled in this court's docket, but the court's going to deny your objection because you can't object to a bench warrant. You can appear that day if you want, but if you don't, the court basically, the bench warrant's already been issued. You were too late in filing this objection.
I found that out, Your Honor.
So it's on the court's docket, but you need not to appear. The next time you need to appear is June 4th before Ms. 6 at 1 p.m. June 4th.
Yes, Your Honor. So the 24th is no longer a thing, correct?
So be at my court, it's already on the court's docket. You can appear if you want, but I'm telling you right now, what's going to happen then is that the court's going to simply deny your objection because it's untimely.
Yes, Your Honor. No, I understand.
Okay, so phone calls get $500 posted today to apply toward your arrearages and continue to make $500 each and every month.
Yes, Your Honor.
Okay, anything further, Ms. 6?
Nothing further on this matter. Thank you, Your Honor.
Hey, you're all set, Mr. Griffin. You can step out. Are you Ronald Turner?
Yes, sir.
All right, Mr. Turner, can you state your name and current address for the record?
My name is Ronald Turner Jr. and my current address is.
Okay, that's the address we have in file for you. For the record, Mr. Turner is appearing via Zoom at the request of America, who's also present this morning. Mr. Turner, obviously, you're not complying with orders of this court. That's why before this court for possible contempt proceedings. Ms. 6, can you give the court some background information regarding Mr. Turner?
Certainly, Your Honor. This case has a current monthly support obligation of $245 per month. The arrears balance is $19,817.40. Mr. Turner last made a payment on November 28th of last year in the amount of $380. He does have a previous finding of contempt. It's from July 21st of 2016. It is a first finding and there is a 10-day balance. He was on the 8 a.m. show cause docket with the front of the court today, which had been adjourned over from last month in March, where he stated to us that he had a job and would be making payments of $100 per week, which is why we gave him an adjournment instead of taking him in front of the court at that time. Today, when he came in front of us, he told Ms. Brower that he had lost that job right after our court hearing. We've not received any payments. And so at this time, the front of the court is requesting sentencing on his previous finding of contempt.
All right, Mr. Turner, you're very fortunate that you have not been charged with a felony non-support charge by the Michigan Attorney General when you have arrears of $19,000. You can go to prison for this, Mr. Turner. I'm surprised the Attorney General has not caught up with you. In any event, do you acknowledge you have $19,000 in arrears?
Yes, sir. I'm trying to fix this. I'm trying to get on top of it, but
you gotta pay. Are you currently employed?
I just earlier I had the court date with the front of the court, and I was looking for a job. I did a couple.
Are you currently employed, Mr. Turner?
Yes, I just got a job between 8 o'clock this morning and at 9 o'clock this morning, I got a job at custom staffing for Oric stamping plant in Lima. I start
When do you
tomorrow.
start?
Tomorrow morning at 11.
Okay. Do you work 5 days a week?
It's 4 days for 12 hours each day.
Okay, so what day do you not work?
I don't work Friday, Saturday, and Sunday.
All right. All right, Mr. Turner, the court's going to order you to personally appear before this court on Friday of this week. That's April 5, 2024, 11:15 a.m. And bring with you $1,000 cash or toothbrush, Mr. Turner. Because you want to keep that job, you need to pay $1,000 towards your VERS on Friday. If not, you're going to go to jail for 10 days. You have any questions?
No, sir.
Reach out to family and friends. It's going to apply 100% toward your VERS, Mr. Turner. It's going to benefit you. These are pretty significant VERS. I'm trying to help you avoid being charged criminally by the Michigan Attorney General with a felony non-support charge. So reach out to family and friends. Tell them you got this job lined up, and you can pay them back when you get your paychecks. We need to bring with you $1,000. If you do not appear on Friday, the court's going to issue a bench warrant for your arrest, and the court's going to add on another 30 days to the 10 days. So you can decide. You either you prepare to serve the 10 days when you appear on Friday, or pay $1,000. And if you pay $1,000, of course, inclined to adjourn this matter. You can buy yourself some time, Mr. Turner.
I have to show up in person on Friday?
Correct, because you're going to pay $1,000 cash, or you're going to go to jail.
Okay.
And we'll get you here before lunch. They serve pretty good lunch over the county jail. So $1,000 for your toothbrush. So we see it Friday, 11:15. Personally appear. My court was on the 4th floor of the Monroe County Courthouse. And you're what, about a 2-hour drive?
Yes, sir. And it'll be 5 days in jail?
10 days.
10 days in jail? Oh, okay.
Correct. But you can avoid that by paying $1,000 that morning. So you got a couple days to get that together. Tell your friends and family members that you got this job lined up and working 12 hours a day, 4 days a week. It's a good paying job, and you can pay them back when you get those first couple paychecks. But this will allow you to keep your job, and perhaps it'll prevent the Attorney General from charging you with felony non-support. So you must personally appear, Bronx Court, 11:15, Friday, April 5. Any questions?
No, sir. I will be there.
Okay. Ms. Six, anything further?
Nothing further. I'll prepare that order and upload it to your queue.
Okay, we'll see you on Friday, Mr. Attorney. You can zoom out.
Okay.
Good afternoon, Judge. We're waiting for Mr. Breskel.
There's Mr. Breskel. Mr. Ditto, good afternoon.
Good afternoon, Judge.
Good afternoon, Judge.
Court's now in session, adding on Jessica Navasky versus Stephen Navasky.
For the record, this matter is before the court. Subsequent parties haven't engaged in mediation. This is a Judge Lohmeyer case, and in her absence, this court is hearing the matter. This hearing is being conducted via Zoom. Present is the mediator, Attorney William Godfrey. In addition, Attorney Matthew Lindo representing the plaintiff. Plaintiff Jessica is with Mr. Lindo. In addition, Attorney Anthony Breskel is present representing the defendant Stefan, and Mr. Stefan is also present. Mr. Godfrey, could you please state on the record what you understand to be the party's agreement?
Thank you, Judge. We have one minor child, Lillian, who is 12. The parties would share joint legal and joint physical custody of their minor child. Parenting time would go as follows. Holidays would be as agreed. If there was no agreement, the Monroe County front of the court holiday schedule would be utilized. For transportation purposes, the parent that is to have the child at the start of parenting time would pick up the child at 5 p.m. or at the end of an extracurricular activity that the child may be involved in, whichever is later. The schedule for parenting time would be a 2-2-3, and that would run year round. Mother would have every Monday, Tuesday. Father would have every Wednesday, Thursday. They would rotate Friday, Saturday, and Sunday. This parenting time schedule would start the first day after the parties separate. They currently are residing in the same home, and we'll talk about that in a moment. The parties will cooperate in Lillian's best interest when determining whether more time should be spent with the other parent. Each party would have the option of exercising up to 3 weeks of vacation parenting time per year. No more than 2 continuous weeks can be exercised at once. The parenting time, the vacation parenting time may be invoked by either parent with a minimum of 30 days written notice to the other parent. This vacation parenting time should not interfere with the friend of the court holiday schedule, absent a mutual written agreement of the parties. The minor child would continue in counseling. Child support would be set at the rate of $643 per month, payable by father to mother. That would commence the first day of the first month after the parties separate. A uniform child support order would enter. Base support is $645, ordinary medical $30, a health insurance premium adjustment to father a negative $32, and that would total to $643. This is based on 182.5 overnights to each parent, and father paying $160 for health insurance coverage of the minor child. Income was as noted by the parties on an agreed sheet, and that was $208,052 for father, $40,922 for mother. As to the health insurance, father would continue to cover the health insurance for the benefit of the minor child, so long as the same is available at a reasonable cost. Reasonable cost is defined as father's 6% of his gross income. When father has the health insurance coverage, mother need not provide it or obtain it. Mother would be responsible for payment of the first $454 per year of uninsured medical expense. After that, it would be split by mother paying 20% and father paying 80%. Extracurricular activity costs for the minor child would be shared equally by the parties if they agreed to that activity. If there was no agreement, the parent that enrolled the child in that activity would be responsible for its cost. The parties agree that the child would be involved in gymnastics, theater, and choir. Those are the 3 activities the child has been in or shown an interest in, and that would continue as an agreed upon extracurricular activity. For tax exemption purposes, a father would claim the minor child in odd years and mother in even. This would be part of the child support provision of the judgment of divorce and subject to modification by the court. Father would need to obtain or maintain term life insurance, naming wife as a beneficiary, in an initial amount of $133,000. That is an amount that we calculated to cover father's child support obligation to get the child through graduation, as well as to cover spousal support, which I'll talk about in a moment. This $133,000 may be reduced or adjusted annually by father as he makes payments towards child support and spousal support, so it can be reduced. Father is to provide verification of this coverage to mother on an annual basis. Any questions by the parties dealing with the minor child?
No, there's just one clarification, Bill. I think that in the beginning when you said the Monday, Tuesday, I think you actually said father, and that's the mother's time.
That is correct. Monday, Tuesday is mother. Wednesday, Thursday is father. If I said that incorrectly, it's Monday, Tuesday, mother. Wednesday, Thursday, father.
That's right, John. We agree.
Spousal support would be paid by father to mother, husband to wife, in an amount of $1,636 per month. That would be for a period of 53 months. It commences the first day of the first month after the parties separate. It will be up to mother to notify the friend of the court. Ms. Patrick at the friend of the court has been very gracious in the past. When she is notified mother moves out of the house, she can start that through the friend of the court. So there will be a uniform spousal support order indicating that duration, that amount. The spousal support is non-modifiable. It can never be changed. It terminates upon the happening of the earliest of the following events: death of either party, remarriage of wife, 53 months of spousal support payments. Spousal support as to husband is forever barred. Husband can never come to court requesting spousal support. As to real estate, we have one parcel located at 9310 Castleberry Drive, Temperance, Michigan. Wife shall quitclaim her interest in this property to husband. That quitclaim can be signed immediately but held by Mr. Vidito. That quitclaim deed would be released upon payment of $115,000 to wife. That $115,000 shall be paid within 90 days of the entry of the judgment of divorce. If that $115,000 is paid to wife within the time frame stated, wife would have 90 days in which to vacate the marital home. Once wife vacates the marital home, she cannot return. If husband does not pay the $115,000 within that 90-day period, the marital home shall be immediately listed for sale, and the net proceeds from the sale of that home shall be divided 50-50 between the parties. Husband would be responsible for payment of the mortgage, insurance, and taxes until that property is either sold or the $115,000 is paid and wife vacates. Wife is not on the mortgage. Wife has an interest in a parcel of vacant land in Bedford Township, Monroe County, Michigan. That interest in that property is awarded to wife. Husband's name is not on the property. Wife owns that with 2 aunts. That interest is being traded off by husband keeping a sports card collection. Any questions concerning spousal support in the real estate?
No.
Thank you. Automobiles are divided as follows. The 2021 Ram 1500 is awarded to husband. The 2018 Buick Enclave is awarded to wife. Wife shall refinance that indebtedness on the Enclave within 90 days of the receipt of the $115,000. Upon providing proof of the refinance to husband, husband shall sign the title over to wife. In the interim, husband would be paying the car payment and the car insurance on the vehicle until it was refinanced. Wife will reimburse husband monthly for the car payment and the car insurance payments that husband makes. Wife would be responsible for all maintenance and upkeep on the vehicle until it has been refinanced and put into her name. If the $115,000 is not paid within the 90 days, this payment by the car payment and car insurance by the husband would continue until the marital home was sold and the proceeds divided 50-50. So if for any reason the $115,000 isn't paid, that payment arrangement continues until the house is sold and wife gets their proceeds from the sale of the house. There is a 2012 Ford Edge. Husband will sign the title of that vehicle over to his stepdaughter, Madison, and that would be then her vehicle. She is an adult. She lives over in Grand Rapids, but that would then become her vehicle. She would then be responsible for the insurance on that vehicle. There is a sports craft pop-up camper. Whatever the party's interest is in that camper is awarded to husband. As to the bank accounts, we have a joint checking and savings account at Monroe County Community Credit Union. That account is awarded to husband subject to the following payments. There shall be a payment of $4,220 towards a Citibank MasterCard, which is in husband's name. Wife had a card on that MasterCard at Citibank. Once that Citicard MasterCard has been paid, that account shall be closed. After that payment, $8,774.50 is payable to wife. Whatever is left in that account goes to husband. And if husband cannot remove wife's name from that account, wife should cooperate with that. But if it cannot be accomplished, then that account would be closed and husband would keep the balance left in the joint checking and savings. As to all other bank accounts, each party would keep their own. Husband has accounts at Key Bank in Glass City, and wife has a Huntington checking and savings or whatever else they may have in their name. They each keep their own bank accounts. Any questions on automobiles or bank accounts?
No, Bill. Bill, we're having some internet issues over here, so I turned my camera off to try to improve our bandwidth a little bit.
All right. Retirement. Husband's retirement consisting of a 401k at ProMedica and an IRA at Fidelity are awarded to husband. Husband has an IRA at LPL Financial. That account is to be divided with wife awarded $165,000 via a quadro. That is a valuation date of March 31st of 2024. Ann Pastrana would prepare that quadro, absent a contrary agreement of the parties. The cost of that quadro and any cost by the plan administrator to implement that quadro would be shared equally by the parties. That $165,000 shall be coming pro rata out of all investments held at that IRA at LPL. Any remaining sums in that IRA after that 165 is separated is awarded to husband. Any gain or loss from the valuation date to the division date is allocated to that share. So if it goes up 10%, the 165 goes up 10%. If it drops 10%, the 165 goes down 10%. Wife keeps 100% of her retirements, which consisted of a 401k through the state of Michigan, a 457 through the state of Michigan, as well as an unvested plan through the Monroe County Library System, which I did not put a value to, construing that as unvested and only less than a year in that plan. So I didn't really put a value to that when I did through all my calculations here. Any questions concerning retirement?
No.
Life insurance, we've already talked about the plan that husband needs to keep with wife as a beneficiary for the amount. Any plan that wife may have, she can keep as her sole and separate property, name whomever she desires as a beneficiary on that. It's only term. There's no requirement that she keep that. The parties would file a 2023 state and federal income tax return. Husband can prepare that. Any net refund would be split 50-50. Any net liability would be divided 50-50. As to personal property, the parties are to divide that on their own. I believe they can. They would have until September 1st of 2024 in which to divide that. If for any reason there's a disagreement, they can request a binding arbitration. The sole role of the arbitrator or the sole role of the court would be to enforce the award of the arbitrator. Neither party could ever come to court asking the court to divide the personal property. That would be done via the arbitration process. Absent a contrary agreement of the parties, I would act as the arbitrator. The request of the arbitration needs to be made by September 15th of 2024. If there is no request for arbitration by that date, Each party would keep whatever personal property item that they may have in their possession or in accordance with how they've decided to agree to it. As to debts, husband shall be solely responsible for a Bank of America credit card that we talked about ad nauseum. That has a balance of about $11,600. Husband also has a Chase and a PNC card that is in his name that he solely shall be responsible for payment of. We've talked about the Citibank MasterCard, which is going to be paid off and closed out of that one bank account, and the payoff is the $4,220. Wife will be solely responsible for any bank or any credit card that she may have in her name, including but not limited to a Bank of America and Huntington. Wife may have restored to her maiden name if she so desires. It's Jessica Renee, R-E-N-E-E, Andra, A-N-D-R-A. Attorney fees, each party is responsible for payment of their own attorney fees and cost. As to miscellaneous items, we have various streaming services. Husband is awarded the DirecTV and Amazon Prime streaming services, and he shall be solely responsible for payment of that. The Netflix, Disney Plus, and Costco services, however you want to define those, are awarded to wife, and she is responsible for payment of those costs. The parties have a cell phone plan through Verizon, which is in wife's name. Wife would keep her phone as well as her two daughters' phone. That's the emancipated daughter as well as the party's daughter. And she would be responsible for those costs. Husband can keep his phone and phone number. Husband and wife shall cooperate and go to Verizon to get that separated. That shall be done within 60 days of the entry of the judgment of divorce. Until that phone of husband and his number is separated from wife's plan, husband shall reimburse wife all costs in relation to his phone and phone number. We've already talked about the ProMedica bonus because that was part of the bank account and that's been divided. And the request for reimbursement of student tuition for Madison that was paid for by husband has been discussed and taken into account in the global settlement here. And that is the entire agreement, Judge.
Thank you, Mr. Godfrey. I was just informed that we lost Mr. Breskel just maybe within the last 60 seconds, Mr. Godfrey.
All right. I didn't see him lost.
So we'll see where, if he can recall where he left off.
All right.
Sorry, Judge. Sorry, Bill. We were listening to your credit card breakdown, I think.
All right. Okay. So I'll go back to the credit card, which is my number 16. Okay. I'll start over with that. Husband shall be solely responsible for bank credit cards that are in his name, including a Bank of America, which I had as 11,600 today, Chase, PNC. The Citi MasterCard, which was in husband's name with wife as a user, is going to be paid out of that bank account, $4,220. The rest of that cards there are husband's responsibility. Wife would be responsible for any bank credit card or any credit card that she may have in her name, including the Bank of America and Huntington MasterCard. The Bank of America, for mediation purposes, had $3,307. Huntington was $232. So that was all taken into account, and that's how the cards are being
I'm informed we lost Mr. Breskel once again.
Okay.
We lost Mr. Breskel once again. So I'm going to have him, when he comes back in, have him call in so that we don't have this for a third time. He can call in. We'll give him our phone number.
Wife would keep her bank account or credit cards that she has. At mediation, we considered a Bank of America with a balance of $3,307, a Huntington MasterCard with a balance of $232, as well as any other credit card she may have, and there were some other ones listed in her financial disclosure. All of those, wife is responsible for payment of. Any questions on the credit cards?
No, Bill.
All right. It goes without saying that when that Citi MasterCard, neither party shall charge on that. I'm using the 4,220 figure. That included some operation for the dog from the vet was put on that, but nothing new should be put on that. All right. Wife is awarded her maiden name if she desires to have it restored to her. It's Jessica Renee Andre, A-N-D-R-A. Attorney fees, each party is responsible for payment of their own attorney fees and costs. Miscellaneous items, streaming services. Husband is responsible for payment of the DirecTV, Amazon Prime, and that's awarded or allocated to him. The Netflix account, Disney Plus, and Costco are awarded to wife, and she would be responsible for those costs. There is a Verizon cell phone plan that has 4 phones on it. Wife and the 2 daughters' phones will stay with wife. Husband would be getting his phone and phone number. The parties shall go to Verizon to get that separated so that wife or husband would keep his phone as well as his phone number. That should be done within 60 days of the entry of the judgment of divorce. Until husband's phone is off wife's plan, husband shall reimburse wife for the cost of his phone plus his phone usage on his phone number. I've taken into account the ProMedica bonus that was deposited in the joint bank account, which we've already discussed. And if there was a request for reimbursement or credit for tuition that husband paid for the stepdaughter, and that has been eliminated. There is no credit between husband and wife for the student tuition of Madison that husband paid. If husband wants to try to get any money from Madison, that's between husband and Madison. It has nothing to do with wife. That's the agreement, Judge.
Thank you, Mr. Godfrey. Mr. Vidal, Mr. Godfrey, aptly state your client's agreement.
Yes, that's the agreement.
Thank you. Mr. Breskel, did Mr. Godfrey aptly state your client's agreement? Can
Yes,
we
Your Honor.
begin with Ms. Duboyski, please?
Yes, Your Honor. Thank you. Ms. Boyski, you heard the agreement that was placed on the record.
Yes.
That's the agreement that you want the court to adopt and enter as the order of the court.
Yes.
Okay, and during the course of that mediation, we were assisted by Mr. Godfrey.
Yes.
He was neutral and impartial in helping you negotiate this outcome.
Yes.
You don't feel like that you were pressured into this agreement?
No.
Okay, and you're doing it of your own free will?
Yes.
You're not on any kind of substance that would interfere with your ability to understand the agreement?
No.
Okay, you're not suffering from any kind of mental illness that would interfere with your ability to understand it?
No.
Okay, and this is the agreement you want the court to adopt.
Yes.
A part of that agreement, was spousal support for $1,636 per month for 53 months.
Yes.
You understand that that's unmodifiable.
Yes, I do.
And you can't come back later and ask the court to change that number.
Correct. Yes.
Okay. And then there were certain parenting time provisions and custody provisions that was put on the record. You agree that those are in Lily's best interest?
Yes.
Okay. So in terms of all the other provisions of the agreement, you agree that that's fair to both parties?
Yes.
Okay. Now with regard to the proofs, you recall having me file a complaint for divorce in this matter?
Yes.
Okay, and in that complaint for divorce, there were certain allegations that we made.
Yes.
And those allegations were that you'd been a resident of the state of Michigan for at least 180 days prior to filing,
Yes.
that you were a resident of the county of Monroe for at least 10 days prior to filing,
Yes.
that there's one child born in the marriage,
Yes.
that you're not presently pregnant.
I am not pregnant.
Okay. And that there had been a breakdown in the marital relationship,
Yes.
and that the bonds of matrimony had been destroyed,
Yes.
and there remains no reasonable likelihood that they could be repaired.
Yes.
Those were all true then?
Yeah.
And they're still true?
Yes.
Okay. Have you disclosed all your assets to Mr. Duboyski?
Yes.
You've hidden nothing?
I've hidden nothing.
I have no further questions for my client, Your Honor.
Thank you, Mr. Vidal. Mr. Breskel, first of all, do you have any questions for Ms. Jessica?
No, Your Honor.
Any questions for Mr. Duboyski, please?
Yes, Your Honor. Stefan, you've heard the agreement that was placed on the record? Yes. You freely and voluntarily engaged in negotiations with Mr. Godfrey and myself and the other side this morning and this afternoon, correct? Yes. The agreement that was placed on the record is the agreement you're asking the court to adopt? Yes. You understand we could have eventually proceeded to a contested trial in front of a judge. You could have done better, worse, or the same, but instead of going towards that contested trial, you're asking the court to adopt this property settlement, correct? Correct. You believe it to be fair, equitable, and congruent? Yes. Okay. You've heard all the provisions regarding your daughter, Lillian, and provisions that were stated on the record are in her best interest. Yes. You heard the questions that were asked of your wife. Do you believe that she answered them truthfully? Yes. Are you satisfied with my representation so far? Yes. Have you fully and accurately disclosed all of your assets and liabilities through the course of these negotiations? Yes. Are you hiding anything from your wife? No. Okay. Judge, I have nothing further.
Thank you, Mr. Breskel. Mr. Vidal, do you have any questions for Mr. Duboyski?
Just as it relates to spousal support, Mr. Duboyski, you understand that the spousal support provisions that were put on the record, those are unmodifiable?
Yes. Correct, Your Honor. And as follow-up, you understand that men can receive alimony in Michigan, but you're going to have a forever bar to alimony as it relates to you getting money from Jessica, correct? Yes. Okay. Thank you, Judge.
All right, thank you. Mr. Vidal, you'll prepare the judgment, is that correct?
Yes.
Very well, the court would like to thank and acknowledge Mr. Godfrey for his fine assistance in helping facilitate amicable resolution. The court would applaud the parties for reaching their own agreement. Without question, Mr. and Mrs. Duboyski, the best resolution is one which you both participated in and agree upon as you have today. You're both well served by two capable family law practitioners. Based upon the testimony that's been presented this afternoon, as well as complaint filed this case, court finds that jurisdiction has been established. Court further finds that there has been a breakdown of the marriage relationship to the extent that the objects of matrimony have been destroyed, and there appears to be no reasonable likelihood that the marriage can be preserved. Upon receipt of the consent judgment, the court will sign that judgment. And at that time, the court will order that the marriage between the parties be dissolved and judgment letter granting a divorce from bonds and matrimony. Good luck to both of you. Mr. Ritter, you can submit this judgment, of course, to Judge Lohmeyer for her signature since this case is assigned to her.
I will. Thank you.
So wait, that will conclude this matter. Everyone can zoom out. Have a good rest of the day.
Thank you, Judge.
Thank you, Your Honor. Thank you, Mr. Counsel.
Thank you, Bill.
Thank you.